Welcome to Legal Nurse Podcast. I'm Pat Iyer. This is a podcast that has been sharing content with you, tips, strategies to help you in your business, which I started in September of 2016. We are now in our 9th year, and we love sharing information with you to help you in your practice. Mark your calendars. Our next online conference is taking place February 27, 28, and March 1 of 2025. We have our act together. We've got this conference planned for you and available for you to reserve your seat at the lowest rate by going to lnc.tips/February 2025 virtual. That link again is lnc.tips/February 2025 virtual. There's no spaces in that link at all, particularly between the February and the virtual. lnc.tips/February 2025 virtual. We'd love to have you join us at that conference and get the benefit of the expertise of our speakers and our topics, all designed to give you the knowledge, the support, and the networking that you need as a legal nurse consultant. And now, let's get on to the show.
Hello, everyone. Good afternoon from the East Coast. Pat and I are excited to share our knowledge and tips for you in your legal nurse business, things that can help you. Today's session is confidently handling attorney inquiries. You receive a call from a potential client. What do you say? And how do you do it to demonstrate your knowledge and get hired for a case? We will have plenty of time at the end of this session to answer your questions. At this time, I'm going to introduce my co-host, and that's Pat Iyer. As an LNC with over 35 years of experience, Pat Iyer successfully used a variety of marketing strategies to create her large independent legal nurse consulting business called Med League Support Services. After she sold the company in 2015, she returned to the field in 2021 and serves as an LNC business coach.
Thank you, Barbara. And many of you know Barbara, who serves attorneys as an expert witness both for med-surg and orthopedic cases. She's a clinical scholar at Mass General and works pretty much every weekend. And whenever Mass General is able to twist her arm and say, Barbara, could you pick up an extra shift? She gets a lot of those calls. We both served LNCs through our roles as presidents of the American Association of Legal Nurse Consultants. And then Barbara also served the state of Massachusetts when she was on the board for 8 years, including 3 years when she was president, which was a purely voluntary, unpaid role that I remember, Barbara, probably took you at least 20 hours a month to go through all of those cases of nurses coming before the Board of Nursing.
Yes, and sometimes a week. We had so much going on. As legal nurses, are you curious about what techniques can help you navigate conversations with attorneys with ease as a new consultant? Today, we are going to discuss when the phone rings and it's a prospective client. What do you say? How many of you freeze and are not sure what to say first? Could you put that in the chat? What do you say when the phone rings, and how many of you freeze when the phone rings and you're not sure what to say? Just wait and see what people write in the chat. And Pat, thank you for the beautiful introduction.
You're welcome. I see I do, I freeze, my phone hasn't rung yet. Oh, then this is perfect timing for you, Carolyn, because that's what we're going to focus on. Krista said, I was wholly unprepared. And a few other absolutely freeze, unprepared. Sounded like a dork. Patrice says it's very nerve-wracking. I used to freeze. We're going to take you through this process of from freezing to thawing out. Thank you, Teresa. I love that and that phrase. I used to freeze and now I'm thawed out. All right.
I love that too. What critical information do you need to ask? How do you do this? These are a few of the questions that we're going to provide answers to you. How many of you utilize intake forms to assist you with this process? Do you have intake forms? Can you respond in the chat?
So if you have an intake form that you fill out when you get a phone call, please put Y or yes in the chat or no. And sometimes is also a choice too. Yes, I see that. I see a real combination of answers in the chat between, it seems to be fairly divided between yes and no. Sometimes, somehow I never have the form handy. We've got a response, not yet.
Great answers. Thank you for sharing your honesty with us so we can help guide you. Today, we're going to offer you tips for organizing your intake process. So I'm aware that some legal nurses keep a notebook. Others have an actual form for doing that intake process. This session today is going to give you solid information to guide you with your calls. From all the intake forms that I've seen and those that I've assisted with creating, Pat Iyer has the most comprehensive intake form that I've ever seen. So let's talk about intake forms and how valuable they are to help you with your conversations with attorneys. By designing an intake form, you have the opportunity to have all the bullet points there. They're all written out for you so that when you are having your phone call, you just follow the bullet points, answer the questions, ask the questions, put the responses into that form, and you won't miss any information because there are times that people freeze, as we've heard today, or maybe can be forgetful about what additional questions they should ask. And at the end of the call, people oftentimes will say, oh my goodness, I should have asked X. Well, we're going to talk about that today. So what can you do with an intake form? Well, it's used for guidance and it provides you lots of information, rich information. I know that Pat has shared that she makes copies of this intake form on colored paper that can go into a client folder or even a 3-ring notebook. I've seen others keep colored notebooks and have everything divided alphabetically. Others are by date and time. So people can have a variety of systems. It's important to include the date and time of your call so that if there's questions in the future about what specific task or role you are asked to do, you can refer to that. That's so important because there have been times I've heard from people stating that they thought that they were locating an expert and then later they were asked by the attorney, where is their chronology? Well, the call was specifically to locate experts, and you, the legal nurse, can go back and explain the details of that conversation and certainly offer to write that chronology if he's looking for chronology, or if you don't do chronologies, locate others that can do that for you. One-stop shopping is certainly helpful, that you have the right connections to help guide that attorney to finding all the answers for his needs. So we're going to talk about what information should be on this form. And as I mentioned, you definitely want to have the date and the time of the call. And how were you contacted? Well, was it phone call or was it an email? And who wrote that email to you? So you want to include those items on your form. Was there a referral involved? How did the attorney find you? Was it through another legal nurse colleague? Was it through another attorney? Was it through even a physician? Whomever that is, it is definitely helpful to find out who referred your name. So then you can go back to that individual who referred you and offer them, write a thank you note, perhaps send a gift card to Starbucks or Dunkin' Donuts or something showing your gratitude. And certainly they'll be very happy to refer your name again, I'm sure. You're encouraging positive, positive feedback by promoting this. A very important item to find out is, what is the timeline that the attorney needs this work done? Is it a rush case, or is it something that can be done within however many weeks? Generally speaking, a rush case is anything that is less than 3 weeks of time. I have heard from other legal nurses who have utilized the 2-week time mark. It varies per the individual. If you are, for example, if you are the expert on a case and you are working in the hospital, there are times that your work schedule and your legal nurse schedule, you're trying to find the time to balance both. And so by having that 3-week time, that will assist you in getting everything done that you need to do. But as I said, this can be individual. And while today we are not going to talk about rush rates, that could be certainly for another conversation, but definitely keep that in mind too, that you want to make sure that you have a current curriculum vitae and a fee schedule outlining what your role is and what you are charging for your different roles as a legal nurse consultant. If you're an expert, if you're doing rush work, if you are reviewing medical records, if you are attending independent medical exams or defense medical exams, these are some of the items that could be on your fee schedule. But again, today we're not devoting the time to those items because we know those could be a session in itself. Other things that you want to have on the form: the name of the person who contacted you. Is it an attorney? Is it a paralegal? Is it a legal nurse consultant? Who is it that contacted you? And what is the name of the law firm that the person works with? So very important to know. There have been times, actually, I received a call this morning from an individual asking me if I could handle a complaint, if they could hire me to handle a complaint before the Board of Nursing. And I had to explain to them, I'm not an attorney and I do not work directly with clients, those clients. I work with attorneys, and the attorneys are the ones that are hired by individuals. So important to note. What is the address of the firm? Where are they located? What city, what state? What is their phone number? Do they have a fax number? Some do, some don't, because we're in the digital time that we are actually scanning so many documents. And certainly, what is their email address? Because you want to have all of that in front of you, and you want to be able to forward the various items that the attorney is requesting if he selects you to work with him. And if not, certainly writing a thank you for consideration email to the attorney, and for him to consider you for future cases is always very helpful to get your name out there. I mentioned about finding out the name of whoever referred you. So in the law firm, what is the name of the legal assistant or the paralegal or the secretary? There are attorneys that have a designated person that fields all their calls and that you may work very closely with. You want to know that person's name, so then you can communicate openly with them, make meetings with the attorney through that individual. And I suggest that when you are writing to your attorney client, you might want to CC their assistant on there as well, so that if you're planning a meeting, both of them will see that email and the assistant can put it on the calendar. So these are a few things that you are going to want to include on your form. And there are times that legal nurses may want to send a gift. I mentioned you may want to send some type of gift to the person who referred you. Or if at the end of the case, a paralegal or a legal nurse perhaps went above and beyond assisting you with things, perhaps sending them a little something at the end as well. So at this time, I want to talk to you before we go on with our intake form. I want to talk to you about one of our LNC Success conferences that we have in the near future that will be in February. And Pat and I have actually run 10 LNC Success conferences. They are virtual, they are live, online, where you participate. And this is so exciting because our next one is February 27, 28, and March 1. And as you know, Pat and I have lots of experience teaching legal nurses. And we've been published in multiple areas, and certainly we enjoy teaching. Many of our sessions have to do with building a business. We will talk about standards of care. We will talk about utilizing LinkedIn. There are so many wonderful topics. Mastering negotiations when you are a legal nurse, and even preventing medical errors. And for those of you who continue to be clinical in a facility, this is certainly helpful for you to bring back to your facility. And for those of you that are looking to be legal nurses and are practicing, certainly this will provide lots of information for you as well. We will have lots of hands-on workshops, and we have attorney presenters, business presenters, and very experienced legal nurses as well. So at this time, Pat is going to address some additional items that you're going to want to have on your client intake list.
Thank you, Barbara. I wanted to first respond to a couple of comments in the chat. They bring up good points on what Barbara has already covered. One person said she used to do referral thank yous. An attorney was all over that in a deposition a few years ago when she was being deposed. That's an interesting insight, Teresa, and it's one that I never ran into in all the years that I ran my company, that anyone would question why giving a thank you gift to somebody who referred work to them would be in some way suspect or could be used to attack an expert witness. So I'm not sure why that came up. I can just say from my experience, it was a rare event. I believe that attorneys who refer work to each other would have no trouble sending a gift or a thank you note to somebody who's given them a case that's going to make them a lot of money. That's why it is fascinating that the attorney thought that they could get leverage with you on a simple thank you or a gift as a result of getting a referral. I'm not sure, Barbara, if you have ever encountered that. Anyone questioning, did you give a thank you note as a result of a referral?
I have never received questions on that. Now, I do know that in certain states, the attorney offices have to turn over every piece of communication that I've had with them, and that will come up before I testify, for example, at a deposition. But I'm not necessarily I may not have sent the thank you yet. It may have been after the deposition, after we've done a lot of intense work together, and then the thank you will go out. But definitely a very interesting comment. Thank you for sharing.
Yeah. There's always little quirks that come up that might be a one-time only experience in a deposition, and make us pay attention to the fact that there are attorneys who are like little bulldogs who are digging and digging and digging, looking for anything that they can to question an expert witness.
Now, Denise Harvey just wrote, "Thank you for your thoughts on the rush time frame. I was told 1 week by an LNC, but 3 weeks for me due to my hospital work schedule." So, yes. Now, certainly there are times that you have an existing case and you're getting additional information. So the rush fee wouldn't necessarily be 3 weeks from that point because you're already involved in a case. So if you are involved in a case and somebody needs something within less than, let's say, 5 days, they're sending you additional depositions, information on a matter, and they require your immediate attention, then yes, you could charge a rush fee for that, but that would be more around the 5-day mark.
And the rule of thumb, Denise, is that there is no consensus about what makes a rush time frame or what makes an increased rate because it's work. I practiced for many years without charging a rush rate. And then one day an attorney asked me to turn something around in a week. And he said to me, "Pat, if you have to charge me more in order to get this done quickly, I'm happy to pay." And that was one of those read my lips messages to me. And then it turned out that many of our cases were rush cases. We started putting in place a rush time frame and an increased rate, and we made a lot more revenue that way because we were doing rush work, and the expert witnesses who we subcontracted cases to were doing work on an expedited basis. So we split that rush fee and kept part of it and gave them part of it.
Now, this next segment, Pat is going to talk about what important information you need when you're getting this new client and the type of case that you're receiving.
There's a couple more questions in the chat that I do want to address. Heidi had a similar experience with being questioned about the referral process. Of course, if you don't know Teresa, she makes fabulous brownies and she gives brownies as gifts. And then Diane Honigoski asked about when is a good time to send a thank you. Our practice was to send a thank you immediately after the attorney contacted the law firm as a result of a referral. The thank you note and the gift went to the referring attorney with a handwritten note that I wrote that said, "Thank you for referring John Jones to us. He contacted me about looking for an ICU nurse for his case. I'm confident that we can provide him with a well-prepared expert. I appreciate your thoughtfulness." Verbatim, that was what I said, handwritten. We had nice little cards with the logo of the company on the outside, very nicely hand done, and then the envelopes were printed with our return address. And we kept a stack of them in my office, and I wrote those notes. My thought of doing it immediately was Pavlov's thinking, the dog gets rewarded for putting his paw on the bar and out comes a pellet. I want to reward my referral source for thinking of me and immediately thank them while it's all still fresh in their minds. Okay, let's look at the second part of what you want to include when you get an inquiry. First of all, to indicate whether this is a client who you are working with currently, and is this a prospect who's never worked with you before? Are they currently representing the plaintiff in the case, or are they representing the defendant? That's important for you to know. We had a most memorable experience one time with a nursing home expert who thought that she was working for the plaintiff attorney, and we had contacted her about defending a case. And she wrote a report without being asked to and without talking to the attorney first, and she sent it to me for proofreading. And I looked at it in horror because she had written a beautiful case for the plaintiff. But our client was the defense attorney. And what we realized is that we had to be absolutely crystal clear at every step in the process of subcontracting cases. We are working for the plaintiff attorney. We put it in an email. We put it on the outside of the folder that we sent to them. We put it on a letter that they got, reiterating, this is the side that you're on, so that they wouldn't violate that set of steps that led to her writing a report that was completely unusable. It's important also to know the name of the case, and it is a good practice to use the name of the patient. The plaintiff could be somebody different. The plaintiff could be a husband, a parent, somebody else, or a child of the patient. Why the patient's name is so important is sometimes there are two names on the file. There is the plaintiff's name and there is the patient's name. We got into an awkward situation right before I sold the company. And I was working right after I sold the company, and I was working with the new owner. And I got a phone call that revealed to us that the name of the patient in our file was a person who was from Vietnam, had a Vietnamese name, but the mother, it was an obstetrical case, the mother had a name like Susan Smith. There was no way that we would have connected Susan Smith with the baby's name, which was completely different. And we ended up, through an error, accepting the case from the defense, who was representing the mother's name, and then the plaintiff attorney had already contacted us about the baby. Now, it turned out the case was indefensible. It had to do with a ruptured uterus during delivery, and there was a delay in recognizing that the woman's uterus had ruptured. The baby was thrust out into the abdomen and had an anoxic brain injury. And we couldn't find anybody who could defend the case. But I had the uncomfortable experience of having to talk to the plaintiff attorney and saying, we screwed up. We ended up taking the same case from both sides. It was horribly embarrassing. And everybody, both the plaintiff and the defense attorneys, were very kind and didn't castigate me and didn't rant and rave, and understood why it had happened. And it reinforced the importance of being extremely clear who you are working for, what's the name of the patient, and making sure that you have no conflict of interest. That was an absolute conflict of interest for us to be on both sides of the case. Completely incorrect. You could have a conflict if you went to nursing school with the defendant nurse and you were asked to be an expert, or if the physician who was being sued was somebody that you go to, or if you are working for the hospital and this is another hospital in the same healthcare system. You can't interfere with who's giving you your paycheck and work for individuals or entities that are too close to that paycheck. Also, you may have certain types of cases that you receive inquiries about, and you want to have a place to indicate, is it a nursing malpractice case, a medical malpractice, personal injury, nursing home malpractice? Maybe you do a lot of product liability or toxic tort cases. You can check off the type of case on your intake form that helps you when you ultimately put this information into your database. If the defense attorney contacts you, it's helpful to know, before we continue.
Hi, good morning. My name is Laura Conklin. I have been a legal nurse consultant for close to 20 years and have a lot of experience in a lot of different areas of legal nurse consulting. The one thing I really have to focus on conferences is the variety. The speakers are phenomenal. They touch on subjects that you would never think that even a legal nurse consultant could be involved in helping with some of the situations that are presented. But as long as I've been a legal nurse consultant, there's always something you can learn. If you're new and you're kind of not sure what you can contribute or how to get started, this is the best place to do it correctly. There's a lot of companies I've heard of, and there's a lot of people that will kind of guide you and then leave you flying on your own. That doesn't work. Whether you're new or you're old, there's always something that you can learn. And it's amazing, the variety and the help that is available. There are people across the country that you can talk to, that you can ask questions. They ask you questions, and you help each other out. That is a rarity in this day and age. Everybody wants to keep, well, this is my idea. I'm going to keep it to myself. That doesn't happen. The wealth of knowledge is shared, and that is priceless. Because where else are you going to talk to somebody in California when you live in New York? Well, how do you do it in your jurisdiction? How do you help out? I have this situation and I don't know who to ask. You're going to get contacts. You're going to get people that are interested in what you have to say, not just what they have to say. And it is really, I hate to say sisterhood because we got a few guys in the group, but it is really a camaraderie where we're all on the same page, assisting attorneys, assisting the legal system, assisting even law enforcement in what do we do as nurses and how can we help you understand what the situation is or situation was, or what the future situation might be for the individuals that get into this legal system for whatever reason. It is really priceless. You get suggestions. You have such an ability to learn some of the tricks of the trade. And believe me, there are tricks in this trade. And after a few years, you get really wise to how do you do this? How do you say this when they're asked this question? How do you answer this? So they're valuable conferences, even though some of the topics you think, I'm not interested in that. You'd be amazed what you find out and you become interested very quickly. Highly recommend.
Who is the insurance carrier? Because you might be in a position where the defense attorney says, I submitted your bill to the carrier and I know that they're going to pay it. If you know who the carrier is, that gives you a leg up if you have to start making collection calls. And who is the attorney representing? The attorney could be representing a doctor, for example, but the position of the defense is that the nurse was negligent. So you could be acting as a plaintiff nurse, I'm putting this in air quotes, to defend a doctor because they're trying to shift the blame. Or a woman falls in a restaurant, goes into the hospital, and they remove her cervical collar without x-raying her neck, and she ends up being paralyzed. They're suing the restaurant. They're also suing the hospital. Who does the attorney represent in this? Who is their client? That's important to know. Then you have an opportunity to ask questions. You want to know what happened, when it happened, what is the attorney looking for? When it happened is important if the attorney wants you as an expert witness, for example, to look at an 18-year-old case involving a woman who was in labor and delivery. Do you have that requisite experience 18 years ago? Or if the attorney wants an expert witness, you want to know what was the time frame to make sure that somebody you're referring was actively working in the area at the time. That's why it's so critical to know what is the date of this incident, what's that time frame, so that you can know where you are related to that experience if it's a liability case. If it's a personal injury case, that's not critical. But if you have to establish that you or somebody you're going to refer was actually in that area when it happened, then that date becomes essential. And then also you want to know the deadline. How soon does this attorney need this turned around? Barbara mentioned if you use, for example, 21 days. I've had attorneys say, what happens if I send it to you and I tell you that I need it in 22 days? Well, then it's not a rush. You have to have a cutoff that makes sense for you and also is going to be palatable to the attorney. Sometimes attorneys, particularly those representing medical malpractice plaintiffs, will say they need an affidavit of merit. That's a term that's used in Florida, in New Jersey, in a variety of places, or a certificate of merit, which is a Pennsylvania term. In some states, the attorney writes that document. In some states, they want you to use a form and fill in the fields. There's a variety of ways that those are handled. So it's important when you're talking to a plaintiff attorney who says that they're representing a patient involved in a nursing malpractice case, for example. What are you looking for? And do you have a deadline? Some states will require an affidavit of merit before the case is filed. Other states will say it has to be turned in within 60 days after the attorney files it, and there might be an extension. That's up to the attorney to tell you, because the attorney should know those deadlines and what the law is. And then also, it's important to ask about how big are these records? I have laughed at times when attorneys have said to me, oh, these records are voluminous. I must have 200 pages. Barbara could go through 200 pages in probably 3 hours. That's not our definition of voluminous. When you start adding zeros to that, that becomes voluminous. The other aspect of that question is that if the attorney says to you, I've got 20,000 pages of medical records, as an example, you might choose to ask for a larger retainer than you ordinarily would. I typically recommend a 10-hour retainer for most cases, unless they're very brief, like a brief emergency visit, for example. But if the attorney tells me 20,000 pages or 10,000 pages, I might ask for 20 hours instead of 10. That would be a judgment call on your part. It's also helpful to ask who else and what else. These are two critical questions in the sales process. Who else means who else in your firm might be interested in using my services? And what else is, what other cases do you have that require the assistance of a legal nurse consultant? When you do that, even if you don't get answers to those questions right away, you're planting a seed in the attorney's mind of, oh, this nurse could help with other things or with other people I work with. And Teresa put something in the chat that's along these lines. Could we get started on the next case? Another way of saying, what else do you have that needs attention? Denise is asking, are you asking different questions if it's plaintiff or defense? The only difference, Teresa, is that you're asking for the name of the insurance carrier if it's a defense case. And they typically don't have certificates of merit or affidavits of merit. That's something that the plaintiff attorney is required to turn in those states where they are needed. Not every state requires an affidavit of merit. Some states want written reports. Some states don't want written reports. There's all kinds of variations. In some states, experts are deposed. In other states, they're not even named, like in New York. I know we've got some New Yorkers here. In New York, they don't name the expert, they don't depose them. They walk in the courtroom and the other side typically doesn't know who they are unless they've been able to kind of ferret it out of the attorney has sent in a certificate that says, my expert is a graduate of Yale New Haven School of Nursing and worked in Hartford Medical Center for 20 years as a director of OR. Well, there are people who sit in New York State and they put those clues in and they try to figure out, is it her? Is it him? Could we figure it out in advance? New York is unusual in that respect that they don't reveal identities.
I know we've received some great questions, and at this time, I'm going to encourage anyone else who has some questions to write them in. We know this session could last so much longer, and we're so happy that you joined our first power session, Confidently Handling Attorney Inquiries. Please mark your calendars because our next session will be November 12, 2024 at 12 noon Eastern Time. And the topic will be using AI to create content for LinkedIn. Would you like to be notified of our future sessions? If you're not receiving our emails, please go to lnc.tips/LNC Power Notify and put your information in there so you're not missing any information. And these are free power sessions for you.
Well, Patrice asked about the retainer. The amount that you received is subtracted from the total amount of charges that you send. That is correct, Patrice. If you work on a case, you have 10 hours of time that you have put into it. You've gotten a 10-hour retainer. You're even. But what often happens is that you find while you're reviewing this, that it's going to take you longer than the 10 hours. We recommend that you replenish the retainer, meaning you go back to the attorney and you say, I know that you send a 10-hour retainer. I'm just at about 8 hours. I think it's going to take me maybe 4 hours to finish. I'd like you to send another 10-hour retainer. That retainer goes into a separate bank account, like a savings account that you set up specifically to keep retainer money. And then when you have earned it, you can move it out of that bank account and put it in your checking account. The reason that you don't put the retainer check in your regular checking account is that you might spend it. And if you finish that case and there's leftover time that you didn't use, it's your responsibility ethically to return the unused portion of the retainer. If you mingle it with the rest of your funds, that may create a problem for you in terms of cash flow. Attorneys respect LNCs enormously when they return unused portions of retainers, because not all people do, especially physicians. So it's a delight when somebody calls and says, I still have money for this case. You don't know if that money came from the law firm or did it come from the pocket of the patient. You're returning it to the law firm because they're your client and they can handle it however they wish. At the end of the year, I had a practice of looking at all the money that was sitting in the retainer account that was collecting dust. It might have been sitting there for a year, several months. And I would call the law firms and say, can you tell me the status of this case? Oh, yeah, we settled that. Oh, well, I've got money allocated in my retainer account for that case. I'd like to refund it to you. Those calls were returned faster than any other call that I ever made to a law firm. Oh, yes, let us check on that and we'll get right back to you. And off the checks went and it cleared out the books, and then we started the process again the following year.
Well, we've had some great questions here, and I want to encourage everyone to join Pat and I at our 11th virtual LNC conference, and you will hear about proven strategies for landing your first attorney client. You'll hear more about marketing tips, which you'll hear with our next free conference at free power session, as I mentioned, utilizing AI. You will hear about clinical topics, case studies where the legal nurse was invaluable to the attorneys. You'll hear about standard of care, preventing medical errors, and so much more. And in addition, for attending our conference, you will receive an extensive workbook that will have slides and toolkits for you, as well as templates. So this is a must attend. We've had great feedback at all of our conferences, and we actually have people who have attended our LNC Success conferences since our very first conference. We have a group who haven't missed a single one. So please see our link, lnc.tips/February 2025 virtual. We'd love to see you then.
And I'm going to answer another question and then share a little bit more for the next 10 minutes or so. Some of the psychology that goes into these intake questions. Brenda asked about an average rush fee. Is it a flat rate? It is highly variable, Brenda. You can charge a specific additional amount per hour. You could potentially double the fee. It's entirely up to you. I had a very conservative rush rate that I put on cases, and I never had anyone ever complain about that additional rush rate. It was very conservative and small, but it added up when you put 10 hours of time into a case. Even a small per hour increase makes a big difference. You want to be conservative as opposed to liberal in this, and kind of test the waters if you haven't used a rush fee before. We would love to tell you that it's set in stone. This is the rush fee that all LNCs charge. There is no such piece of data out there. So it's up to you how you want to increase the rate. It has to be worth your while if you're working weekends and evenings, if you're working Monday through Friday to try to get something completed. You do have the right to be compensated for putting aside other cases or other responsibilities to get work done. I will tell you a very important tip, which is make sure you get a retainer before you do the rush work. Because to my sorrow, I took on a rush job from an attorney who was a new client. Number one, warning sign. Number two, it was a rush job. He contacted me on a Friday, wanted it done on Monday. That's the third warning. And then I turned it in to him, and he spent the next 5 months before he paid me for the work that I did. And I was burned by that. And I said, never again will I do that. You can receive money through FinTech, through Zelle, through bank transfers, through an overnight check, through a credit card if you're set up to receive credit cards, through PayPal. You do pay fees when you use PayPal, and you do use fees when you accept credit cards. There's a monthly fee, a transaction fee, and a 3 to 4%, depending upon the credit card fee. They pull out 3 or 4% of what you have been paid to satisfy them. So that's an expensive way to accept money, and used to be the only way before we started being able to bank on our phones and use Zelle and similar applications. So there's lots of choices for them to get the money to you in a hurry. And I emphasize how important that is, because you don't want to be resentful that you spent time, you gave up time to get something done quickly, and then you can't get paid. That to me is an outrage. Not that I have any passion on this topic. It's burned in my brain. I even remember his name. A little bit about the psychology before we finish up. And that is, when your phone rings, smile. Make it a habit of whoever is on that phone call. Always be friendly and smile. That will come through in your voice. I had an assistant for a couple of years who was the friendliest person. She would get the attorneys laughing. They loved to talk to her. And she immediately set up a very pleasant atmosphere when she answered the phone. She moved on to another job. I replaced her with somebody who was clinically depressed over problems with a boyfriend. She used to go down into the basement of my office condo and cry. And when she answered the phone, it was, hello, this is MedLake Support Services. My clients started to notice, oh, what happened to the person that you used to employ? You know, where is she gone? You know, why can't I talk to her anymore? You want to start that atmosphere right from the beginning by being friendly, being genuinely concerned. This is when you put on your nursing persona and you are thinking about how you can help that person. This is not a stretch for us. This is what we do. We walk into a room. If you think about somebody who's laying in bed, they're in pain, they're scared, they don't know what's going on. You walk in, whether you're doing that right now or you've done it in the past, and you establish a rapport. You make that person feel comfortable with you. You exude confidence. This is the same principle, the same communication technique of having people feel like you know what you're doing. And you might not have ever done a case like some of the people who are listening to this program. When the attorney says to you, and very few do, but when the attorney says, well, you know, have you ever worked on a case before? You can say, I know there's a person on our program who spends her life auditing ER records. She could say, back when she became an LNC, she could say, while I haven't worked for attorneys yet, I've spent the last 5 years, 40 hours a week, looking for quality issues in medical records. And that's the absolute truth. You could have done auditing, you could have analyzed records in other aspects of your clinical work. So it's important to answer questions honestly if you get those kinds of questions, but give it a spin that emphasizes, I've been reading medical records for the last 15 years. I know how to interpret a medical record. It's working for attorneys that might be new, but the act of analyzing records may be different. You also have this phone call with the idea, the expectation that you're going to get the case. You're going into this feeling positive about this. You know that the attorney has to take a leap of faith to hire you if they've never worked with you before. I had one attorney probably in 1987. He was the second attorney that I ever spoke to. He wanted to know if I had ever testified in court. I said, no. He said, well, I won't hire you if you've never testified as an expert in court. And I said, well, if people feel like you do, I'll never get hired. So I think it's important to give me the opportunity. He said, well, somebody else can take that risk. The third person who hired me didn't care if I had ever testified in court. The first call I got was a case that disappeared and got resolved, and the attorney dropped it. The second call was this guy who wanted me to have history testifying. The third call I got was a guy who said, all right, it's November, we've got a trial date in January. I said, oh my goodness. I thought I would have experience as an expert before I had to go to trial. And I testified in January. Well, that took care of the argument. From that point on, do you have any experience? So stand firm in your value. You may encounter some people who are calling LNC saying, how much do you charge per hour? How much do you charge per hour? And they're just taking notes and going right down the list. Those people are called tire kickers. They are economic buyers. They're evaluating you based on how much you charge per hour. They're not going to be the strongest clients that you're going to work with, and they may end up challenging your invoices as a result of their focus on the bottom line. We know that cheapest is not always best, and often there is not a direct correlation. People who know their value set a rate that's reasonable and they stick to that rate. They don't respond when the attorney says, "Could we negotiate that rate?" No, we can't. I met a physical therapist in Manhattan one time when I was exhibiting, and he said, "Pat, when they ask me if they can change my rates, I say, my fees are my fees are my fees." And I still remember him standing on the sidewalk with this little tilt of his head and this expression on his voice of, "That's it. I'm not going to negotiate with an attorney. This is it. This is what I charge." So be careful of attempts by attorneys who want to take an inexperienced individual and negotiate down, or the person who himself is new or herself is new to medical malpractice, who is surprised that a nurse would charge that much per dollar per hour. They clearly haven't seen hospital payroll since the pandemic and are out of touch with how nursing salaries have changed as a result of shrinking workforces. We deserve to be paid for our value and our experience. Barbara, are there any comments on the chat before I wrap up with a few more thoughts?
So there are a few comments. Someone stated that they had an embarrassing problem, that their first call, they were unprepared and too excited, and the attorney found her on LinkedIn and asked her rate, but she had no clue, and it was a Zoom call, and he could tell that she was flustered. So he actually helped her feel better by saying, "Well, you just started your business in February." So sounds like that worked out. And there are other comments about working as a sub. If any of you have future topics you'd love to hear at a power session, you can email me at bjlevinlnc@gmail.com, and Pat and I will chat about the future topics. So we're so happy that you joined us today. And I know Pat wants to wrap up.
Yeah, for that unprepared call, it's a great idea to have already thought through your fee structure and have a current resume or curriculum vitae that you have available that you can send off at a moment's notice, particularly if you get the sense the attorney wants an answer right now. You don't want to have to try to construct that document if it's not current. Camara asks, if you worked as a sub, would it be a concern if you potentially take a client that maybe your primary once had? Usually, if I understand your question, Camara, correctly, if my company, Mid-League Support Services, which I owned at that time and no longer own, hired a subcontractor, we would say to that individual, "We've introduced you to this attorney. You're going to be working for the attorney through us. If the attorney comes back to you with another case, we'll bill for that work. But this does not prevent you from working with anyone who finds you in any other way." You could say, Camara, "Well, Bill found me over here. I didn't realize that Bill already worked for that LNC company." That's not a violation of an agreement because the company did not introduce you to Bill. Bill found you independently. And you can't possibly know the database of the LNC company. They're not going to say, "Camara, would you like to have a list of our attorneys so that you can be sure to not work with any of them directly?" That would be a very trusting offer. And most legal nurse consulting companies are extremely protective of their client base, and they're not going to share the names of their clients with their subcontractors, only the ones where there was that direct introduction.
Excellent.
Kathy had a question, understood about not discounting fees. There are public defender cases. Yes, Kathy, we're aware that the public defenders don't have the same kind of budget as an attorney in private practice, and you may choose to work with them at a different rate. And that's good business practice. I worked for the New Jersey Assistant Attorney Generals and gave them a different rate because they gave us a lot of work. And they also didn't argue about hours. They would say, we need a chronology done on this case involving a fall that occurred in a prison. Would 20 hours be enough? There was always a generosity associated with that. So you can set up exceptions, but you want to be careful, though, that if you're working in the medical malpractice arena with private attorneys, they compare notes. So you don't want to say, oh, for the defense, I'll give you the work for this, but for the plaintiff, for the same type of medical malpractice case, I'll charge you this much. That's the thing that gets you in trouble. And you can get confronted with inconsistencies. How should we handle attorneys who keep scheduling appointments and inquiries with you and keep standing you up? Oh, I would suggest talking to the person who controls the attorney's schedule. It might be that there was a misunderstanding. It might be that there was a last-minute change in the attorney's schedule. Maybe the attorney could take your cell phone number and could text you if they know that they're not going to be able to make an appointment. It's an incredibly demanding role to be in a law firm. And having spent time with my clients in those buildings, I can see the constant changing of needs that occurs over the course of the day. But I do remember going to an attorney's law firm for an appointment and finding out after I drove an hour there that the attorney wasn't available. And I remember how I felt about that because I had put my time out and got behind the wheel to drive. They did give me work later on, but it was uncomfortable. Yes. Barbara, I know that we could go on for a lot longer, but our commitment to you is to get you out of here, remind you once again to go to the link, take advantage of the lnc.tips/February 2025 virtual. We have currently a super early bird investment for the 3-day conference, which also comes with contact hours as an optional fee. And we would love to have you join us for even more education. Also, go to the link that Barbara shared so that you can be notified of future sessions. If you're not getting our emails, then by going to this link, you'll be tagged as indicating that you would like to be notified about future power sessions. tips/LNC power notify. There is no space in the second part of that between LNC power notify. Kind of looks like an RN, which it is, power notify. It's all one phrase.
Pat, I want to read a beautiful comment to us from Krista. You ladies are genius, and so giving to us LNC's cheerleading for our success. And that's the goal that Pat and I have, to help all of you. So we'd love to see you at our next power session, which will be November 12 at noontime. And we'd love to see you at our February 2025 conference, the LNC Success Conference. So start your new year off on the right foot. Join us and you will network with many, and you will learn so much about business, standard of care, other practice areas for legal nurses, and so much more. So we thank you for joining us.
The lnc.tips/LNC power notify is to get on our notification list about programs, and the lnc.tips/February 2025 virtual is the link that goes right to the next conference. It's also on the homepage of Legal Nurse Business. You can go to legalnursebusiness.com and you will see an image that will take you directly to the February 2025 conference. Thanks so much for being with us, and we will see you again approximately a month from now, when we will be talking about how to shortcut content creation using the powers of AI, and specifically how you can create content and images that will help you in showing your knowledge on LinkedIn. That's the focus of next month's program. Thanks so much. Coming up next, you're going to have an opportunity to hear from a woman who is a whiz at referrals. Tiffany Kellogg is an expert on the multi-step process, simple multi-step process that you can use to obtain referrals. Would you like more clients? Would you like your happy clients to bring in people who are already predisposed to working with you because their friend recommended you? Tiffany goes through a 5-step process in the program that you're about to watch. This is one of our most popular sessions from our prior conferences, and you will have an opportunity to see Tiffany's system. You may get the most out of this program by watching it on our YouTube channel, which is Legal Nurse Business, and you will find the video program. The audio program, of course, is available on all of the audio stations. Thanks so much. Enjoy Tiffany's program. Coming up next. Thank you for being part of our audience of Legal Nurse Podcast. I hope that you enjoyed this session and you got some great tips from it. I would love to see you at our February 2025 LNC Success Online Conference. That will be our 11th conference, taking place February 27, 28, and March 1. You can get your ticket by going to lnc.tips/February 2025 virtual. I'd love to see you there.